To someone desperate for cash, signing a piece of paper for a loan may be done without a thought about how much that quick loan will actually cost. In State of New Mexico ex rel. King versus BNB Investment Group, we'll explore how the unconscionability doctrine provided an extra measure of protection for unsophisticated consumers. BNB Investment Group was a payday loan lender. BNB operated in New Mexico because the state didn't place a general cap on loan interest rates. Consequently, although the payday loans consisted of small principal amounts, typically ranging from $50 to $300, BNB charged over 1,000% annual percentage rates. BNB targeted its loans toward indigent New Mexico residents, particularly those who were unbanked, meaning they had little to no banking or financial knowledge or experience and would be unlikely to understand the concept of interest rates. BNB pushed its borrowers to increase their principal debt, made misleading statements about daily rates of loan payments, and didn't disclose amortization schedules. Loan terms were completely determined by BNB and non-negotiable. Contracts for loans were on take-it-or-leave-it terms. Claiming that the loan terms were unconscionable, New Mexico's Attorney General sued BNB on behalf of the loan borrowers in the United States District Court for the District of New Mexico under New Mexico's Unfair Practices Act. At trial, an expert testified that unbanked indigent borrowers tend to focus on easy short-term gains and had unrealistic expectations about their ability to repay the loans. The district court held that although the loans were procedurally unconscionable, they weren't substantively unconscionable because there wasn't a statute capping interest rates. As a result, the district court granted the state a permanent injunction prohibiting some of BNB's practices, but not the interest rates. Both parties appealed to the 10th Circuit, which certified the question to the New Mexico Supreme Court.